This is not a temporary measure. Once it's done, it's done. Today I'm talking about a very serious part of family law that's extremely rare, but it has severe consequences. That is termination of parental rights. So why would somebody's parental rights be terminated? Well, there's several grounds for termination, including abandonment, abuse or neglect, mental illness or incapacity, failure to support or communicate with the child, and more. Each case is unique, and it's essential to assess the situation thoroughly. The process begins with the filing of a petition for the termination of parental rights at the appropriate court. Then, once the petition is filed, the court will review the case. DFACS, the Department of Family and Child Services, may get involved as well, or may even be the entity that brings the termination process. The court process for termination of parental rights involves hearings where the evidence against the parent is presented, and then the parent has the opportunity to defend themselves. The court's primary concern in these cases is the best interest of the child, so they'll take into account various factors before making a decision. What's interesting about this termination of parental rights process is that it's one of the few types of cases in civil court where the defending party, in this case a parent, is given an attorney if they cannot afford to hire one on their own. Now, in criminal cases, everybody knows that the defendant gets the right to an attorney if they can't afford one. It's even part of the Miranda rights, which are typically read to them when they get arrested. But in civil cases, such as car accident lawsuits or divorces or modifications of custody, and most other lawsuits that don't involve an arrest and aren't criminal in nature, there's no free attorney given to the defending party. But with certain civil cases, such as a termination of parental rights, the consequences and the nature of the case are so severe, which is the taking of a child from a parent, potentially on a very permanent basis, that the Constitution guarantees the right to have representation before the state can issue such a ruling to sever a parent's rights and their relationship with their child. After a full evidentiary hearing, if the court determines that the termination of parental rights is warranted based upon the evidence presented, they'll issue an order to that effect. This terminates all legal rights and responsibilities of the parent toward the child, including custody, visitation, and child support. After a parent's rights are terminated, the child's placement then depends on the circumstances and the best interest of the child. Now, in many cases, if there's other family members who are willing and able to care for the child, such as grandparents, aunts, uncles, or other relatives, they may be considered for placement. Otherwise, the child may be placed in foster care or with a pre-adoptive family if adoption is planned for later. The ultimate goal is to ensure the child's safety, well-being, and stability in a nurturing and loving environment. Termination of parental rights is usually permanent in most cases. This is not a temporary measure. Once it's done, it's done. However, there are situations where a parent may be able to petition for reinstatement of their rights in the future, but this is rare and it requires significant proof of rehabilitation in changed circumstances. Hey, thanks for watching this video. Be sure to click subscribe, like, follow, and turn on the alerts so that you'll get notified when we post our newest videos. Please share these videos, leave us some comments, ask us questions, tell us what other topics you'd like for me to talk about. Join our Facebook group at Georgia Divorce and Custody for more information. And as always, I look forward to seeing you on the next video.